Hello and welcome to the third and last episode of ELP's Trade Dialogue podcast on CBAM. CBAM has been widely reported amongst lawmakers, policymakers, student, academia, and lawyers. ELP has been closely following the developments around CBAM. And in our last two episodes, we were joined by Arnoud Willems, who is a partner at Baker McKenzie, and Dr. Badri Narayanan, who is an economic expert on the subject matter. And both these gentlemen helped us understand legal and economic motivations behind CBAM. Today, I'll be joined by my colleague Sanjay, and we'll try to decipher the discussions we had with Dr. Badri and Arnoud, and also discuss key takeaways from there. Sanjay, welcome back to ELP's podcast, and let me get straight to the issue. You heard Dr. Badri talk about CBAM, Arnoud also explained CBAM. I want you to understand from you, what are your initial thoughts about CBAM as an instrument?
Thanks, Parth. So, firstly, I would agree with Dr. Badri that several aspects of the CBAM regulation are unclear as of now. For example, the methodology to calculate embedded emissions while also accounting for carbon costs paid in the host country is likely to be notified by an implementing act, or even the exact procedures and modalities to apply for authorization or make declaration by Indian exporters have not been notified yet. That said, what is clear that the CBAM will negatively impact exporters of the designated products to the EU, as it would basically increase cost for these exporters. Absent compliance, access to the EU market will be significantly impacted. But more importantly, I think countries are concerned with the manner in which the externalization of the EU laws are being strong-armed into accelerating their progress towards mitigating climate change and the Paris climate agreements, what we had particularly agreed upon. This is particularly concerning for developing countries such as India, Brazil, Turkey. While India has undertaken ambitious commitments regarding climate changes at various forums, it would like to achieve these goals in a manner consistent with the economic and social development. Recently, India has also voiced its concerns at the WTO about border adjustment measures such as CBAM, clearly nullifying the negotiated balance of rights and obligations under multilateral agreements. It would be interesting to see how it pans out at the WTO. Parth, one of the things which comes to my mind is, what are your thoughts on the compatibility of the CBAM with WTO laws?
Well, thanks, Sanjay. I mean, that's a bit a complex question. And before I come to that question, you mentioned about EU externalizing its laws. And the way I see it, it has gone a step beyond what Arnoud Bradford had called what you call the Brussels effect, right? When Arnoud Bradford coined that term Brussels effect, what she meant at that point in time was that, EU was taking this regulatory leadership. And what companies used to do is that even when they are not required, they would follow EU standards. And therefore, there was this sort of a contagion effect, which they call as a Brussels effect, that even though EU is formulating laws for its own, people are following it, and in fact, the world follows the EU law. But this with CBAM, it has gone a step ahead, and the way it has framed it, it's almost de jure legislating for the others, because everyone has to comply with the now EU CBAM law, and if you don't comply, you essentially lose the market, and therefore there is economic coercion behind this. So I think this is a bit a serious issue in terms of how you see in whether it is WTO consistent or this would be too premature right now, because look, at the face of it, there could be potential issues around MFN national treatment. Just to explain, for example, MFN, the essence of MFN is non-discrimination, right? Any imports which are coming from any of your partner countries, you cannot treat one more favorable than others. Now, countries who would have a ETS system, which is, let's say, linked with the EU system, their products will get a green signal when they enter into EU market, but others will not, right? And to that extent, there could be an issue of discrimination. Equally, somebody can also put a defense that whether these two products are like products to begin with, because one product has actually paid the carbon cost and the other product has not paid the carbon cost. Now, whether that should be a factor in determining whether they're like products or not, those are the questions will arise. So it is very difficult to say at this point in time whether it is consistent or not. But surely, what one can say is that this law will not go without a WTO review. Now, question is that who will actually call the shot? With WTO appellate body being dysfunctional, EU trading partner, interest of different trading partners, somebody has to really, bell the cat here, if I can say that. So let's wait to see what happens from here. Anyway, that brings also to my next question, which is that right now we understand that there could be concerns with the law's compatibility with WTO rules. But given that WTO appellate body is not functional, and to that extent enforcement at WTO is completely nil, I would say, what realistic options do you really think exporters from India who really have a focus in the EU market, what realistic option they have?
So Parth, I am glad that you have asked this question, and clearly given the background what you've given to us at the WTO, some of the options which are clearly, unless the Indian government is able to negotiate a carve-out, and that also in the short term because of the timelines which we are all aware about, I don't think Indian businesses have any other options other than complying. And this is exactly professionals like us, trade lawyers such as us, along with some of our colleagues in the EU are trying and working around to facilitate some of these Indian companies to sort of charter their next path if they want to comply with CBAM. Likewise, clearly, if they do not comply, the nature of the border adjustment mechanism is such that their access to the EU market will be significantly impacted. In any case, you have brought up this issue about the WTO compatibility, and clearly we all understand now that even that too will not yield any short-term solutions because of the enforcement of the rules is currently in suspension due to non-functioning of the appellate body. And therefore, given the last few cases of the WTO, India is also unlikely to be a party to the alternate appeal or the arbitration arrangement, which is the MPI, for obvious reasons. So therefore, challenging the legality of the measure is unlikely to yield any solutions for the industry as of now. And that's where I think the possible things stand. But Parth, you mentioned about the possibility of a carve-out. Can you please help us to delve into that issue a little more in detail? And clearly, if there are any other options that we should be thinking of?
Yeah, so thanks, Sanjay. First of all, I agree with you. These issues are complicated. There is no easy solution to it. As far as carve-out is concerned, the carve-out could be done at two levels. One, both India and EU have shown and rekindled their interest in getting into FTA. India is pushing for FTAs, and I think EU has a strategic interest in having a FTA with India. Certainly. So both parties, perhaps, at least India can ask for a waiver or a carve-out from CBAM, application for Indian exports, at least for certain defined period of time before they enter into FTA. But whether that will be a deal breaker or not, it's anybody's guess. The second could be that India could, outside the FTA, diplomatically, if it can, ask for a waiver, if not for everyone, perhaps for MSMEs or some other sectors which India thinks is going to be deeply impacted. So that's on what they can do. The success of this largely depends on how much appetite both countries have to accommodate each other, right? As far as any other option is concerned, surely India is at a nascent stage of right now framing its ETS structure or carbon trading structure, so to say. And because it is at a nascent stage, India could also possibly think of designing a trading structure which is aligned with the way it is done in EU, so that it can be linked with EU ETS framework, and then Indian exporters, it will be easy for Indian exporters to take benefit of the CBAM law, in the sense that if our trading system is linked and recognized by EU, then it can be whatever certificates you purchase here, that will be easily, I would say, transferable in the EU. So these are the two options which I think right now India can consider, or Indian policymakers can consider. But that said, that brings to me my next question, which is that Dr. Badri and I spoke at length about various measures which companies can take at this point in time, including having this voluntary trading system. What do you think about that?
So Parth, you've already answered this question, but let me just labor on it a little more on this. Yes, you're right that the structure of our voluntary carbon trading system is rather crucial. But based on the recent news reports, which suggest that India is in talks with the EU to recognize its own carbon credit trading system, linking, of course, these trading systems will allow importers to claim a reduction of the CBAM certificates it needs to surrender in order to consider the carbon price already paid in the country of production, which is India. But it is unclear if India is going to be looking to link its trading system with the ETS, since the carbon credit trading system, which is proposed by India, is structurally very, very different from the EU ETS. It will therefore be interesting to see how this plays out for both the countries. And as I said, even based on the methodology, how exactly is the emission going to be calculated for like products, and the manner in which we are going to then run the certification process. All of these are challenges, all these are procedures which need to be sort of in sync. And I think it's a test of time that we will have to see how exactly this plays out for both the countries. But we also spoke previously about the importance of proper measurement of emissions produced at country and company levels and both the levels. Dr. Badri also spoke about being prepared to invest significantly in research and development. I thought that this was an excellent practical advice for companies. Any thoughts on that?
No, I completely agree with Dr. Badri on that. I think it's time that India, you'll have to take a head start on that. You'll have to start investing in right R&Ds here, so to say, so that you can see that how you can measure your emissions. I can't really emphasize more on the importance of that, because look, CBAM is a reality. And like I said at the beginning, it may have a contagion effect of CBAM in the sense that other countries will adopt similar laws, if not exactly the same law. So it doesn't harm. In fact, Indian industry should put efforts to have proper measurement systems at place, so that they are in compliance with whatever form and measure in which carbon adjustment mechanisms can come in whatever form. And I think they should be prepared for that. So I completely agree with them. I don't think India has an option to not to do that. Okay, that takes me to the next question. Of course, all of this requires adoption of greener technology at a faster pace, right? And because we are talking about R&D, it's important that India has access to technology, right? And technology, as you said, that has been a bone of contention between the global north and global south, I would put in that way. What remedies you think, or what solutions India should pursue on that account when it is, let's say, negotiating an FTA with EU, or when it is at multilateral talks with other countries who are basically pushing for these greener technologies, or faster adoption of greener technology, absent an access to technology or a transfer of technology at a royalty-free basis or royalty-reduced basis? It's going to be difficult. So what do you think? How can India address that issue?
So, Parth, I already see that, which is going to be a major challenge, and it's already a challenge. So I think the Indian industry, of course, should forge along with the government to try and negotiate certain transfer of technologies and know-how at reduced cost. Clearly the royalty issues are going to be under discussion, but under the FTA for a faster greening of its manufacturing processes, I think this is all what we should be asking for. And clearly, in my honest view, if the EU doesn't agree for a waiver, then this is the minimum that India must ask for, because most of these technologies, we are well aware, are being developed at a faster pace in the Nordic countries, Germany, and most of these countries who are part of the EU. So I think it will be very, very important for us to be asking some of those things as part of the FTA. That being said, if Indian exporters want to continue to sell to the EU, then they must be prepared to comply with the CBAM, as I said before. Specifically, they must assess their supply chains, production processes to measure the emitted emissions in their products. They should also consider registering their company's installations, coordinating with their business partners in the EU, finding an accredited verifier that can verify the emitted emissions calculated. Most importantly, since the EU is likely to notify several implementing regulations to clarify the modalities of the CBAM, exporters must therefore seek assistance from professionals to help them keep track of the legal as well as the regulatory developments in the EU. And clearly that is clearly the way forward for now.
Thanks, Sanjay. I think that makes a lot of sense. I mean, only time will tell what exactly will happen, if there will be a waiver or not, or whether, India will be able to persuade EU for transport technology or not. We'll get to see that. I think we are living in interesting times. But in a nutshell, what I understand from you is that Indian exporters who have a focus in the EU market, in a short term, they don't have an option not to comply, because they then risk losing their market to their competitors. And that brings the end of this discussion. Thank you, Sanjay, so much for your time. And I would also like to take this opportunity to thank Arnoud and Dr. Badri, who actually could, devote their time and discuss some of the very important issues around CBAM. We'll also ask our listeners and viewers to give their feedback, and more importantly, if you think there is any other important issue on which you would like us to discuss or get experts to discuss that, we'll be very happy for that. And with that, it's a wrap. It was a pleasure speaking with you, Sanjay. Thank you.
Thank you, Parth. Likewise.